Welcome to the Deep Dive.
Yeah.
Today, we're really digging into a critical topic, financial regulation and oversight here in Australia. Specifically, we're taking a close look at the Australian Securities and Investments Commission, or ASIC.
Yeah, and we have a pretty substantial stack of sources. We're talking articles, legal docs, research notes, and they all center on a Senate committee investigation.
An investigation into what exactly?
Into ASIC's effectiveness, really. Its enforcement, its transparency, the whole package.
And this is, it's a bit of a sensitive deep dive, isn't it?
It is, because we're synthesizing material that was presented publicly by, expert witnesses, executives, lawyers, academics.
Okay.
And we're comparing those public claims against evidence from 36 rejected internal submissions.
Rejected, so the committee never even published them.
Exactly. They came from an organization called VOFF, which tracks issues in financial conduct. So it's the public story versus the story that was kept private.
Right. So our mission here is to get past the headlines and figure out what the core concerns were. Were the same red flags appearing on the public record and in those claims that were dismissed?
ASIC's conduct, its competence, and its whole philosophy on transparency.
And the central tension, I suppose, the big question we're trying to answer is, do they align?
That's it. If these serious criticisms from outside witnesses are mirrored in a body of evidence that the Senate committee chose not to publish, well, that suggests a potential systemic issue, a big one.
Okay, let's unpack this. Where do we start? The most visceral critique seems to be about ASIC's actual conduct, how it deals with people.
Yes, exactly. The first big point of contention is this obligation ASIC has to act as a model litigant.
And that's not just a nice idea, right? It's a requirement.
It's a required standard of conduct for government agencies in litigation. It means they have to be fair, act with integrity, try to minimize costs and delays, be the good guy in court, essentially.
And the sources. They confirm this was a major line of attack. We have Mr. Timothy Hart,
the executive chairman of Southern Cross Payments.
Right.
ASIC appear to treat small, medium companies very different to large companies. In the case of I Sign This, I have no doubt they tried to bankrupt the company with high legal costs, so the matter would never make it to court. They were also supposed to be the model litigant, but it didn't appear that way through the process.
He told the Senate committee point blank that ASIC was not meeting that standard.
And here's where it gets crucial. One of those rejected submissions from VOFF, it tried to introduce 2 letters.
Letters about what?
From a legal firm, sent to the Attorney General's Department, lodging an official complaint that ASIC was failing to meet those exact model litigant obligations.
Wow. So the alignment is almost perfect. The public testimony and the rejected evidence are saying the exact same thing.
Striking, isn't it? Both claim the regulator was sort of not playing by its own rules.
Now, for you, the listener, who maybe doesn't track administrative law every day, what does it really mean when a body like ASIC is accused of this? Is it just legal jargon?
Oh, it's much more than technical. I mean, think about it. If the government regulator, the very entity that's supposed to enforce integrity in the market, is seen as not acting with integrity in court,
it just completely corrodes public trust.
It corrodes everything. It suggests they might care more about winning than about due process, and that just poisons the well between the regulator and the market.
And that erosion of trust, it links directly to some of the most pointed criticisms in these sources, the allegations of intimidation.
Yes.
I mean, it's a general consensus globally, and many people don't speak out about this, that it's effectively, at some level, over-regulated. As I said before, it's insinuate and intimidate. When I was there for my trial, there was I think it was Shipton was the chair at the time, and there was an imperative conference going on, and there was a lot of criticism about ASIC that they were asleep at the wheel when it came to corporate regulation or to regulation. My attitude is it didn't matter if they were asleep at the wheel. If they woke up, they don't even know how to drive the car. I mean, when these people were being cross-examined about, there were people that had designed elements of the stock exchange that under cross-examination could not explain the very part of the stock market they designed. It doesn't make any sense to me. And these were very, I met ASIC on what do they call it, without prejudice basis, against my lawyer's actual advice when I flew into Australia and sat down with them, and we whiteboarded basic trading strategies and certain elements of the market, and I was just shocked at how little they fundamentally understood about trading in general, let alone just Australia.
Daniel Schleifer, he's the president and founder of Select Vantage, Inc.
And he said in his testimony that ASIC used insinuation and intimidation.
He called them tactics of a bully, not a market regulator, which is, I mean, that's a profoundly damaging thing to say about your regulator.
And the VOFF submissions, they tried to back this up with a very specific, almost theatrical story.
Oh, it is theatrical. The rejected submission detailed this private meeting with an MP, Stephen Jones, in Dapto. This was back in February 2013.
Okay.
And the claim was that 4 ASIC staff, all dressed entirely in black,
All in black.
allegedly marched in single file to join the MP at the podium.
That image, 4 staff, single file, all in black. I mean, whether the committee accepted it or not, that paints a picture of deliberate regulatory theater. What does that suggest?
It suggests a show of force, doesn't it? An intentional display of dominance, not cooperation. And if you connect that back, it really highlights this conflict between ASIC's operational style, which witnesses felt was aggressive, and its required standard of conduct.
Yeah, because if you feel bullied, you're not going to see the agency as a fair umpire.
Not at all. It hampers everything.
So if there are questions about its conduct, how it treats people,
Dare try and stop us talking to them. I'm going to make a formal complaint about your presence at this meeting because you as public servants have no business being involved in political issues.
the next logical step is to ask about its fundamental competence. Is it actually effective?
Exactly. And when we moved to that, the criticism was, if anything, even more scathing.
This is where we get that memorable quote about driving a car.
That's the one, from Mr. Schlaepfer again. He said ASIC is asleep at the wheel, but it wouldn't matter if it woke up because it doesn't know how to drive the car.
That is just a total rejection of both their awareness and their skill.
A complete indictment.
And the sources weren't just criticizing market stuff, were they? They were asking if ASIC was actually delivering justice for victims.
And this is where William O'Chee, a partner at Himalaya Consulting, provides some really important context. He said, part of the role of insolvency law is to ensure justice.
Right.
But, he claimed, ASIC is simply not rendering justice to victims of financial crime.
The role of insolvency law is twofold. It is, first of all, to ensure economic efficiency, and secondly, it's to ensure justice. And when I use the word justice, I think in terms of what the Emperor Justinian said in the sort of 7th century, that justice is the constant and perpetual desire to render to each person that which is their due. For reasons that will become obvious as I go through this, it is very clear that ASIC is not rendering justice to the victims of financial crime.
And you have Dr. Jason Harris from Sydney Law School basically echoing that, calling ASIC little more than an observer.
ASIC is, at least from my perspective as an external observer, ASIC is a regulator that is incredibly reactive, and as new criticisms come, it's able to deflect those criticisms by doing what we're seeing it doing right now, which is the criticisms coming out of the PJC and others, let's have another restructure. ASIC's always doing something which it can use to deflect against criticism. And yet, I've gone through those 24 years of annual reports looking at the enforcement statistics. The numbers aren't changing enough. So just deflecting that by saying, well, here's a criticism, here's what we're doing here, and we're changing this team and we're merging some of these staff, it's not good enough. At what point do we say, explain to us what you're doing? Now, if they do that even to Senate estimates, even to these committees, even if it's in camera, if there is that accountability, then I'm happy. But I'm not seeing that. I'm seeing the same problems coming up year after year.
So let's ground this in a specific, painful example from those rejected submissions.
Right.
The Trio victims case.
Yeah, the sources on this are really tough to read. The Trio victims, they had invested in a fund that was both ASIC licensed and APRIA regulated. They should have been protected.
The gold standard of regulation.
You'd think so, but they were apparently treated disrespectfully throughout the whole process.
And what was the single biggest failure, according to the rejected submission?
It was. It's just shocking, really, when it comes to victim rights. ASIC failed to tell the Trio victims that they were legally entitled to submit a victim impact statement to the trial.
Hang on. The victim impact statement. For those who don't know, why is that so important?
The Victim Impact Statement, or VIS, is the one formal way for victims to tell the court, the judge, what the crime actually did to them. The personal, emotional, financial damage. It's crucial for sentencing. It makes the human cost real.
So by not telling them.
By failing to inform them of this fundamental right, ASIC effectively silenced them in court. It potentially limited the scope of justice being applied?
It really does raise that question, doesn't it? Is the regulatory action about real justice, or is it about just appearing to be active? Because failing to secure a basic right for victims, it suggests they weren't the priority. Which brings us to enforcement outcomes and public relations.
It does. We have to look at what ASIC publicly calls a success versus what victims would call a success.
Okay, let's look at a specific achievement ASIC was promoting. They announced they had permanently banned a guy named Jeffrey Revel-Reed from providing financial services in Australia.
Sounds good on paper. Regulator takes action, bad guy is banned. A win.
But the full context, as the sources reveal, tells a very different story.
It really does. When ASIC made this big public announcement, Mr. Revel-Reed was already 2 years into an 8.5-year prison sentence.
And not even here. He was in jail in the UK for running a massive boiler room scam out of Spain.
That's right. It involved 1,000 investors in Britain who lost something like $126 million.
So ASIC permanently banned a guy who was already in a foreign prison.
It really makes you wonder about priorities, doesn't it? It feels more like optics than substance. Why waste resources tiding a ban on someone who's already neutralized?
And the contrast gets even sharper when you see how UK authorities handled that same case compared to how ASIC handled the trio victims.
Absolutely. The UK authorities, our sources say, they treated victims respectfully. But critically, they went after the money. They engaged in asset forfeiture to claw back the proceeds of the crime.
So they actually got money back for the victims.
They did. Revel-Reed's assets were sold off, and that money went to repay the British victim.
And back in Australia for the trio victims, whose fund was licensed by ASIC.
The sources state that ASIC made no attempt to claw back the proceeds of crime. The result, not a single cent was returned to the trio victims.
That discrepancy is profound.
Yeah.
One regulator prioritizes getting money back for victims. The other prioritizes a press release about banning someone who's already in jail.
It suggests a completely different definition of a successful outcome. It highlights a massive priority gap. It seems like the visible, easy announcement won out over the hard, complex work of asset recovery.
Which brings us to the core philosophical debate. What is ASIC's actual mandate? What is its purpose? Because this sparked a huge fight over transparency.
This is probably the most critical part of this whole deep dive, because it defines what the public should even expect from their regulator.
And it all centers on a statement from ASIC's chairman, Mr. Longo, to a Senate committee back in December 2021.
Yes, and in that statement, he basically said that ASIC's, and I'm quoting here, regulatory tools and resources are not intended or able to prevent many of the losses that retail investors will experience.
Not intended or able to prevent many losses.
And he justified it. He said, this is true of every financial market regulator. He's fundamentally shifting the expectation away from prevention.
But the VOFF submission, they pushed back hard on that. They said he was wrong.
They did. They pointed to the US, the UK, Europe, and argued that the charges and penalties for financial crimes there are much stronger. Their point was that other jurisdictions do operate with a more effective preventative mandate, which makes Longo's claim about every regulator seem, well, dubious.
There's a logical point here, too. If the chairman says they're unable to prevent many losses,
it implies they do prevent some losses.
Right. If they prevented zero, he'd just say that.
And that logical gap, that's exactly what VOFF went after to test ASIC's transparency. They lodged a Freedom of Information request in January 2022.
What did they ask for?
They asked for proof. Any document where ASIC could clearly show it had prevented the loss of consumer savings through its own intervention. Simple as that. Show us your wins.
A straightforward request for evidence to back up the chairman's own implied claim. What was the response?
ASIC denied the request.
On what grounds?
They cited a practical refusal reason, basically saying the request didn't adequately identify the documents they were looking for.
But how could they? The sources say ASIC put this completely circular requirement on them.
Precisely. ASIC demanded that the applicant name the funds that were saved.
Which is the very information they were asking for.
It's totally illogical. VOFF's point was, we're asking you because we don't know. It's like asking someone for the key to a locked box, but telling them they first have to describe what's inside it.
So what does that refusal really mean when you put it all together?
I mean, refusing to provide a single example of successful prevention, it just reinforces the perception that the ability to prevent consumer losses is either a closely guarded secret, or maybe
it's non-existent.
Right. It raises these huge questions about transparency, and it tacitly supports those witness claims that ASIC is asleep at the wheel. It leaves the public unable to verify if their protector is actually protecting them.
This has been an incredibly revealing deep dive. I feel it's the key thread running through everything is this persistent tension between the public criticism from experts and academics and all that rejected evidence from VOFF. And both sets of material, they're all pointing to the same things, issues with conduct, with efficacy, and with this fundamental lack of transparency.
Yeah, if you connect it all to the bigger picture, these sources give us a really stark look at the challenges regulators face, especially managing public perception versus actual enforcement success.
And tangible outcomes for victims.
Exactly. The gap between successfully putting out a press release about a ban and successfully getting money back for victims is enormous. And the evidence here suggests a real misalignment in focus, leaning towards the optics.
So we've seen the ASIC chairman, Mr. Longo, state that their tools aren't even intended to prevent many losses. That sets a pretty low bar for protection.
A very low bar.
So if a financial regulator cannot or will not transparently show you where and when it has actually prevented consumer losses, as we saw with that FOI refusal, how should you, the public, weigh the risk of investing in so-called regulated markets against the protection you assume you're buying?
That is a critical question.
It's something for you to consider as you track these developments. Thank you for joining us for this deep dive. We'll see you next time.